Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We have two arguments in three cases this morning, two of which are consolidated. Those are the first two, 2256, CPS Energy against Electric Reliability Council of Texas, and 21834 in ERCOT from Bexar County and the Fourth Court of Appeals District. And then second is 22196 ERCOT versus Panda Power from Grayson County and the Fifth Court of Appeals District. The court has allotted 20 minutes per side in the consolidated cases and also in the second case, with some time being allocated to the amicus curiae. The arguments are being webcast live this morning and will be available in the archives later today. We'll finish the arguments before the break for lunch. The court is ready to hear argument in the consolidated cases, 2256 and 21834.
May it please the court, Ms. O'Neill will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
May it please the court. In my time today, I'd like to focus on the issues of immunity and exclusive jurisdiction. Those issues are before you either by mandamus if you decide ERCOT is not a governmental unit, or by appeal if you decide that they are. We will rest on the briefs on our other issues unless, of course, the court has any questions. On immunity, there are 3 points for the court to keep in mind. One, whether a private entity should share in the sovereign's immunity is a policy-laden issue. And despite many opportunities, including after the winter storm, the legislature has never conferred government status on ERCOT, which it knows how to do. This court should not step in to fill that policy void. 2, being heavily regulated and serving a public purpose does not confer government entity status on a private entity that's not created or chartered by the government, funded by taxpayer dollars, or performing a uniquely governmental function. And 3, if ERCOT was determined to be a state actor, it would be a first in the country for an independent system operator, a first for this court for an entity like ERCOT, and it would nullify statutory and regulatory indicators that ERCOT is not entitled to immunities protection. Now, this court has rightly been reluctant to confer immunity without a clear legislative grant, because in the court's words, just as immunity is inherent to sovereignty, unfairness is inherent to immunity. And that's why the court has acknowledged that, quote, it has yet to extend sovereign immunity to a purely private entity, one neither created nor chartered by the government, even when that entity performs some governmental functions. Now, ERCOT was and is a private, membership-based, nonprofit corporation. Before it was certified as the independent system operator, it performed the same grid operation functions that it does today. Those functions did not suddenly become governmental when ERCOT became the ISO, and its certification to perform them didn't turn ERCOT into a part of state government.
Does ERCOT do anything that the PUC cannot control?
It does. It operates the grid. Its operational functions are not really subject to the direct control of the PUC. And let's talk for a minute about the difference between the regulatory and the operational function. Regulation of the grid and the wholesale retail markets is a governmental function. That's what the PUC does. Operation and maintenance of the grid is what ERCOT does. It ensures that electricity supply and demand are perfectly balanced and kept in calibration at all times, and it employs the pricing mechanism that the PUC sets.
So when the PUC sets the pricing mechanism, is that operational control over ERCOT or something different?
It is, let me tell you about the pricing mechanism.
And approves its protocols and its bylaws.
Well, the pricing mechanism is very important, Justice Bland, and I'm glad you raised that question because it took me a while to figure this out, but I think it's very, very important. The PUC sets the rules for how the algorithm will be determined. It sets the parameters for the algorithm. Now, ERCOT's the one who administers that algorithm. It gathers market prices, it takes real-time and next-day data, and it plugs it in, and that's how it determines what the market clearing price will be, but it does not set that price, and it is subject to the PUC's rules on price setting. And that's an important distinction that I think you might hear ERCOT try to gloss over here today. The ERCOT puts a lot of weight on what it calls its public purpose. But as this court said in Rosenberg, engaging in acts that serve a public purpose says nothing about the nature of the entity itself. The question the court posed there was whether the functions the entity is authorized to perform are so uniquely or definitively governmental that only a governmental entity would engage in them. And here that can't be the case because ERCOT was performing those same functions before it was certified as the independent system operator.
One question you might ask when thinking about these sorts of things is, does ERCOT act on behalf of the people of Texas? Does it serve the general welfare of the people of Texas? Or does it act for itself, for a profit motive or for some, private, does it have duties to its shareholders? Is it acting out of private interest, the way we would normally think of a private organization acting, or is it acting for the general welfare of the people of Texas?
Well, it is a private nonprofit corporation, and it was operating as a private entity before its certification. Now, you've raised the question of the public interest, the public purpose, and as the court has said many times, serving a public purpose says nothing about the nature of the entity.
Well, but my question goes more to what are its duties? What are its obligations? When the people running ERCOT wake up in the morning, who do they have to tell themselves they are serving so that they can know, what kind of decisions to make? Is it the general public, or is it some private interest, profit, shareholders, et cetera?
Well, they serve the public interest. They also serve the market participants that they contract with. So there are multiple players in the market, but the public interest, the public purpose, is not what drives the governmental entity analysis. It's the nature of the entity itself, and that's what we look to the statute for. Now, the tort claims...
The legislature meets starting tomorrow.
Yes, it does. We find
If
ourselves...
they wanted to make the policy choice to transform ERCOT into a public entity by nature, a governmental, the nature, not just purpose and functions, but change its nature, what could it do this session to do that? How would that look? What would they change?
How could you make it a public entity?
Yeah, ERCOT as we know it today, starting tomorrow, the legislature decides, let's make it public. Let's make it a public governmental body that is entitled to sovereign immunity. What would the legislature do?
It would do exactly what it did in the Amex Properties case. There, for the open enrollment charter schools, it specifically made those schools part of the public school system of the state, and it directed that open enrollment charter schools are entitled to immunity to the same extent as school districts. So it could make
So
ERCOT
it'd be
a
as
part.
simple as passing a law that says, we hereby declare that ERCOT is, or the ISO, I guess, the selected ISO, is part of the state government and entitled to sovereign immunity?
It would be a harder question. They could declare it. Whether it was so, the court would still have to look at the way it was structured. But certainly it would be a harder question because the court has always put legislative indicators of intent, has always given that primary importance.
We've also said that it's the court's role to decide whether immunity exists as to any given entity, and then the legislature's role to decide whether to waive that immunity. Does the legislature have power to create immunity for an entity like ERCOT?
It would not. But again, the legislature's pronouncement of what it intends in the statute is important. And this court, under the common law, has typically exercised restraint in applying the common law principles to override that expression. Now, it's interesting because the court finds itself in exactly the same situation it was in Panda Power 2. The court couldn't reach the question because it was procedurally prohibited from reaching it, But you acknowledged in your opinion that the public stakes were high in answering the immunity question, and the legislature was in session then. It was early in the session. Justice Blacklock, you noted that the session was underway, and you noted that these issues would be considered by the legislative and executive branches. And yet, even though the legislature knew that the case was front and center, they did nothing to make ERCOT a part of the government.
Since that argument, we do have some indicia of the legislature's interest in ERCOT, in that, legislation reconstituting its board and reserving $800 million of the rainy day fund for the securitization process that the legislature determined ought to be the solution for the defaults. So does that indicate that the legislature considers that it has control over the governance of ERCOT and the finances of ERCOT?
Well, the securitization process that the legislature enacted didn't solve the problem of ERCOT's accountability. It just spread the mistake among different market participants. Now, it did tinker with the way the board was appointed. I would caution the court to stick with the construct of ERCOT as it existed at the time of the winter storm.
But the very fact that the legislature, as you describe it, could tinker with, in other words, could replace and change the criteria for selection of board members, is that some indicia that the legislature at least believed that ERCOT was a state agency whose membership could be constituted and determined by the legislature?
Well, the legislature tinkers with statutes all the time.
Not with statutes, but with the board membership.
Well, that's
and
by
the selection
statute.
criteria for those members.
And that is by statute. And the court, the legislature does tinker with statutes, amend them from time to time for entities that aren't considered part of the government. That was true in Rosenberg. It's true in many different cases. But in terms of the reconstitution of the board, I would say that that is not the type of accountability, political accountability, that this court has held as a sufficient vital counterweight to immunities and equity. And so there's still, you've created now a board selection committee, but still the selection of the board is far too attenuated to be the type of political counterweight to justify immunity's unfairness. But again, more importantly to your question, they did nothing, even though they did that, to indicate that they intended for ERCOT to be a part of the government.
All right. Back to my first question. I want to give you a chance. My first question was, are there things that ERCOT does that the PUC cannot control? And I want to focus you on the word cannot. So I'm not asking, in practice, does ERCOT do things that the PUC doesn't, dictate one way or another? But does the PUC have the authority to control and dictate everything ERCOT does or doesn't do if the PUC chose to operate that way?
It has the power to regulate. It has the power to regulate ERCOT. It does not control what ERCOT does when it turns the knobs on the grid and operates the grid.
But could it? I mean, could the PUC commissioners issue an order that says, you're doing this wrong, and we are now going to dictate to you on a granular level how to do it better?
Well, it did just that with the pricing mechanism. ERCOT did not have the authority to mess with the pricing mechanism, and to the extent it did that, it can do that in certain instances. But your control question, I think, is exactly what the court addressed in Rosenberg. And so maybe we should turn our attention to Rosenberg. If you'll look under tab 6, I think the similarities with this case are striking. In Rosenberg, the ERCOT, first of all, makes a lot of the public interest. It claims that it's an essential player, an important public purpose that it serves. But that was true of the economic development corporations there as well. I'll call them EDCs. The legislature said in the legislation that they serve an essential public purpose. They are in the public interest. And it talked about their nature, purpose, and powers. They're very similar to ERCOT's here. I've listed them here. I don't have time to go over them all, but you'll see they're virtually identical. And the court said that this essentially complete oversight was not enough to confer immunity. If this court follows Rosenberg, it's hard to see how it could possibly afford ERCOT immunity here. Now, one thing I would like to get to, because I think it's an important point, the Tort Claims Act says that a governmental entity's operation of a utility is a proprietary and not a governmental function. And this prompted you, Justice Boyd, to ask a question during the Panda Power argument that I think really puts the finger on the question you asked. If, after ERCOT certification, It was fulfilling primarily the same role it had performed privately before. And if most of its members are not governmental entities, and those that are by statute are engaged in a proprietary, not a governmental function, doesn't it look like the whole system is by design private and proprietary, not governmental, even though highly regulated? And then you came back and you asked again, how could the role of ERCOT in coordinating the efforts of all those retail entities transform that into a governmental function when even at the retail level, its municipalities are engaged in only proprietary functions? I think that pretty much sums it up. Now, I don't have much time. I'd like to hit exclusive jurisdiction very quickly. If you'll turn to tab 8 of your bench book, PURA contemplates 3 specific types of PUC jurisdiction. And I would ask the court to keep these charts in front of you because it synopsizes the way jurisdiction works under PURA, and I think it will help you when you're hearing argument from the other side on exclusive jurisdiction. The 3 types of jurisdiction are exclusive original jurisdiction over the rates, operations, and services of an electric utility, appellate jurisdiction from the rate decision of a municipally owned utility, and concurrent jurisdiction over disputes with ERCOT. Now, in looking at the regulatory scheme, it's important to recognize the code's distinct treatment of the retail distribution service market and the wholesale market. CPS Energy's claims concern the wholesale market. Now, the retail side governs public utilities. There are 4 in Texas. There is Oncor, CenterPoint, Texas New Mexico Power, and AEP. They own and operate the wires and the equipment that move power from generators to consumers. Their rates are set by tariff under the filed rate doctrine, and they're passed on directly to consumers. That's what I call the retail side, and that's what the PUC is expressly granted exclusive original jurisdiction over. If you'll turn to page 2 of that tab, you'll see that 11002A of PURA expressly establishes a comprehensive and adequate regulatory system for electric utilities to assure rates, operations, and services that are just and reasonable to the consumers and the utilities.
So let me ask you, so it sounds like you're not relying on whether or not these are purely legal questions, right?
I'm sorry?
It sounds like you are not relying on whether or not these are purely legal questions.
No, I think you need to understand the 2 different sides of the market, wholesale, retail. I think what this will show you is the legislature intended heavy regulation
Right.
of the retail side, but intended to open up the wholesale side for market competition. And I see my time's up. Can I finish my answer to your
Yes.
question? If you'll look again at the chart, you'll see that on the wholesale market side, this is what PURA says, does not lend itself to traditional electric utility regulatory rules, policies, and principles. That's 31001C, and you'll also see that there's no concomitant comprehensive regulatory scheme expressed in statute. Thank
Any other questions? Thank you, Ms. O'Neill. We'll hear from the respondent.
May it please the court, Mr. Clark will present argument for the respondents.
Mr. Chief Justice, may I begin?
Yes.
May it please the court. CPS Energy complains that the price of energy in an emergency scarcity event was too high and that it should not have to pay those excessive prices for the energy it consumed during Winter Storm Uri. In the next ERCOT case the court will hear today, power generators claim that ERCOT's forecasted scarcity of power was untrue and the future price of energy was too low for their investments to be as profitable as they'd hoped. But here, rather than follow the regulatory process it has followed before, PUC filed suit in its hometown district court complaining about ERCOT's core functions to administer the wholesale market and to ensure the reliability of the grid. CPS claims that ERCOT improperly set the price of energy. That claim belongs in front of the PUC. The PUC has the expert agency knowledge to dispose of that claim, and PURA is a pervasive regulatory regime that allows it to do so. There are already appeals and lawsuits against the PUC complaining about those pricing orders. They are all following the regulatory process. There are market participants who have begun disputes at ERCOT that will work their way to the PUC. Those claims are approximately $3.2 billion. They are following the regulatory process. CPS Energy did not follow the regulatory process, and if it is allowed by this court to pursue the same issues in its hometown district court, then all of those other market participants will abandon the regulatory process and go file suit in their hometown district courts. Quite literally, chaos will follow.
We've said in various cases that we don't, and when we're analyzing exclusive jurisdiction, we don't send whole claims to agencies. We send particular issues to agencies. So which particular issues in ERCOT's common law, I'm sorry, in CPS's common law claims are you saying belong in front of the PUC?
Well, all of them.
Well, surely not whether particular common law standards were violated or how much damages are awarded.
They're common law in name only. Their claim is that ERCOT violated a PUC order. Their claim is that ERCOT violated the protocols.
That's their only claim?
Their claim is that all of their claims
They
are
also had gross negligence and
based on violating a PUC order and the protocols in PURA.
so which issues belong in front of the PUC?
Whether ERCOT violated PURA, whether ERCOT violated the protocols, whether ERCOT violated the PUC's orders, which they've, through their briefing, reduced their claim to, although you'll see in Exhibit C in our bench book, their petition alleges much more. But even if they had asked the court to amend their petition, which they've never done, even if they did that and they went back and said, ERCOT violated the PUC's order by holding the price for 33 hours, that is an issue that only the PUC can decide. The notion that they have a remedy in the courthouse is actually a false notion. The Fifth Circuit held in TCE versus TXU, it's cited in Calpine's amicus, that courts are judicially barred from hearing that kind of claim, that a rate is too high, excessive, or unlawful. The filed rate doctrine would not give...
The filed rate doctrine doesn't apply in state court.
Sure it does. This court applied it last year in Ramirez to a non-customer.
Well, we're not going to, I mean, we have a presumption that state district courts have jurisdiction rather than that they don't.
Absolutely. Absolutely. If the PUC were to find that ERCOT had violated its order and that the price was incorrect, it would order a market-wide resettlement. So at that point, there's no reason for CPS to go back to Bexar County to say, well, it was negligent. The resettlement has to happen at ERCOT. Otherwise, the entire wholesale market falls apart. If Bexar County says, well, the price should have been different for CPS, and Harris County says, well, the price should have been different for our local rep, we'll have different prices across the whole state. And so in that sense, I think all of the issues, except for constitutionality, which if they want to, after they go through the PUC process, if they think there's still something there, they can go back to a court to hear that.
Your brief said that they would have to do, they would have to challenge under the, using a substantial evidence standard, but I take it that's not your position for the constitutional claims, that those would just be initiated as a regular lawsuit.
Correct. Whatever underlying fact findings the PUC may make would be subject to that standard, but whether or not the protocols themselves are unconstitutional, protocols that CPS voted in favor for, protocols that it says in the ordinary course of business there's nothing wrong with. It's just that now that we're in an emergency and the dollars are higher, they say it's unconstitutional. But yes, that constitutional question would not be subject to that. The court would decide that.
And by the same token, it would not be barred by immunity if we agreed with you that there was some sort of sovereign immunity or governmental immunity that attached to ERCOT. That wouldn't apply to the constitutional claims or any claim of taking based on reallocation of debt or debt service.
Absolutely. Just as any immune entity is not, doesn't have immunity for a constitutional claim, neither would ERCOT, and we don't say so.
What are we to make of the regulation that the PUC issued that nothing in this section shall preclude any form of civil relief that may be available under state law?
I think that's 362J maybe, and that is only between the PUC and ERCOT. So, and they admit as much. If you look at the introduction to 362, that provision is to claims between the PUC and ERCOT. Has nothing to do with market participants.
So which one allows for suits, which one allows for market participants
22-251 is the PUC rule by which any affected entity can complain to ERCOT, or pardon me, complain to the PUC about ERCOT's conduct and misconduct or failure to act, including violations of the protocols, violations of PURA, or violations of PUC orders.
And what's the statutory authority for that regulation?
39151D gives the PUC complete authority over ERCOT's operations and to ensure that it carries out its functions, and it allows the PUC to take appropriate action against ERCOT if it doesn't carry out its duties.
To be clear, what the statute does is it gives the PUC complete control over the operations of the certified ISO, not ERCOT, right?
It is if you see the sentence prior to that, and this is in Exhibit A of our bench book, an independent organization certified by the Commission is directly responsible and accountable to the Commission. The Commission has complete authority to oversee and investigate the organization's finances. So
Yeah.
it doesn't say ERCOT in there, but ERCOT is that independent organization. It is who
But
the
to me,
PUC
that's a key point on the immunity issue, is that the statute never talks about ERCOT. It just talks about the certified ISO, or independent operator. And ERCOT happens to be the certified independent operator. And I guess the question I have is, what would it look like just as a practical matter? Of course, the statute says the state can certify more than one ISO, or independent operator can have one or more, which of course we don't. We have just one. And just from a practical standpoint, I'm struggling to figure out what it would ever look like to have more than one, or what it would look like to replace one.
I think it would be very difficult to replace ERCOT, but there is a procedure in place in PUC Rule 364 to decertify. You transfer the assets and liabilities, but ERCOT is actually defined in PURA 310025, and it's defined as the region in Texas that's not synchronously connected outside of the state. Texas is unique, right? We are the only intrastate wholesale market and electric grid under state control. Likewise, ERCOT is unique. Its essential intrastate role is required by legislative command in PURA. And so I think I was going to focus mostly on exclusive jurisdiction, and I know we'll hear about immunity in the next case. But to the immunity point, this court said in Incarnate Word versus Reedus at page 409, certainly the legislature authorized private university police departments, but it did not mandate them or fund them. The opposite is true of ERCOT. The legislature mandates that there be a PUC-certified independent organization under 39151A and C, and it funds it under 39151E. The legislature did not mandate that we have charter schools or that schools can have self-insurance pools, but those were found immune in Ben Bolt and Amex properties. Here, the essential role that ERCOT fills as the independent organization under PURA is mandated and funded by the legislature, and I think that has to go a long way.
It's not funded by the legislature. It's funded by the fees that are paid under the authorization of the scheme created by the legislature.
Well, by virtue of the legislature creating the system administration fee in 39151E, it allowed for ERCOT to be funded. So
Right, but it's not appropriated funds.
They're not appropriated from tax dollars. However, the legislature allows this fee to be created, and it says how it should be spent.
But that is a big difference, whether or not it's actually funded by appropriated dollars.
Well, I don't think this court has ever said that a regulatory fee means that an entity, if that's how it's funded, should not be entitled to immunity. And I think that would be a major change in the law. So,
Well, we've also never said that a private entity is entitled to immunity other than a charter school.
ERCOT is not a purely private entity in the sense that the charter school was chartered by the commissioner of the education agency. ERCOT is certified by the PUC to fill a legislatively mandated role. So I don't think it's it's fair to characterize ERCOT as a purely private entity in the sense that
But
the
it's
court was...
composed, the board's composed largely of market participants, right?
No. No, the legislation now says that
At
no...
the time we're talking about.
At the time we were talking about, primarily, I think it was 8. I don't know if it was the majority. I don't think it was. But there were market segments that served on the board.
And then they selected most of the rest of the board members, right?
I believe, I have to get back to you on that. I believe that the PUC approved any non-affiliated or board members, but I'm not entirely sure about that.
But I believe they were selected by the other board member. Maybe they were approved by the PUC, but I guess it seems like one of the themes in our jurisprudence is that political accountability, that if you're going to give somebody immunity, there's got to be political accountability. And if you've got market participants who are on a board, it seems like there's a unique danger of lack of political accountability.
Well, as I said, Justice Busby, there are no longer market participants on the board, and the legislature has said that, in fact, if you have any assets or fiduciary responsibility in the ERCOT market, you may not serve as a board member.
So why should we look at that if that wasn't the case at the time of the conduct that went on? I understand if another case comes up, we'd have to look at that again, but what's the relevant time period here?
I think you should look at it for the same reason you looked at it in Amex Properties and in Redis and in all the other cases where we say, here is this later legislation, and does that inform our analysis of what the legislative intent is? Is it an indicia of whether the legislature considers ERCOT to have the nature, purposes, and power of state government? And I think the fact that it now has created a committee that the governor, lieutenant governor, and speaker appoint, and that agency now appoints the board members, is clear indicia that the legislature views ERCOT in that manner.
As between immunity and exclusive jurisdiction, do we need to take one of them up first? If we agree with you on both, does it position on which one comes first, or do we address both? How do we handle that?
I think immunity should come first, but I think addressing both is appropriate as well. I mean, just as addressing the governmental unit holding of the Court of Appeals is important.
Why would we address both if they're both getting you to the same result here?
Well, if you were only to address one, then we would think immunity would be the most appropriate. It would apply as well in Panda as well as in other cases.
Well, I guess another way to ask that is, if we believed that immunity applies, if we concluded that immunity applies, could CPS still pursue any claim before the PUC?
Oh, absolutely. Absolutely.
But only if the PUC has exclusive jurisdiction?
I don't think...
Or does it not matter either?
Well, it's an interesting question. I don't think there's ever been a dispute by CPS that they could have brought this complaint to the PUC. They've done it before, as we have in the record. They've gone to the PUC when they say ERCOT didn't follow a PUC order and they got its invoices wrong. They went to the PUC and they won. And the PUC ordered ERCOT to resettle those invoices. And so I think if you were to say that we are immune, the PUC would have jurisdiction over this dispute by CPS. It's the only place they can get the remedy that we're after.
And if the PUC has exclusive jurisdiction, would it matter whether, I guess it would matter, it would still matter whether ERCOT has immunity or not, because once the PUC decides what it can decide, CPS would still have to get to court to get the ultimate remedies it wants?
Yes, I think I'm following the question. So if they follow the regulatory process, their avenue will be, as the Fifth Circuit just pointed out in Just Energy, to follow that through to Travis County under the APA.
But if ERCOT is protected by governmental immunity or sovereign immunity, then CPS could get whatever it wants out of PUC, but it could never finish the race, right? Couldn't go to court?
Well, it would go to court, but it would be over the PUC's finding against the PUC in Travis County
It'd be
under
merely
the
a
APA.
judicial review suit.
I'm sorry?
It would be merely a judicial review suit under the APA?
Correct.
Well, in the constitutional law claims,
And the
because there's two
Constitution.
pieces of immunity. There's immunity that an agency might have, and then the question is whether the legislature has waived that immunity.
Absolutely. So if they,
And there's some indicia, there's references to gross negligence and intentional misconduct. There's references to other civil relief. Is there some indicia that the legislature has not waived that has waived that immunity with respect to some conduct that ERCOT engages in?
no, those references are in the PUC rules, and I don't think we look to those rules for immunity waivers. I think we look to legislation and statutes, and those issues are not there. However, if ERCOT were deemed to be immune, it would be subject to the same sorts of immunity waivers that the PUC would be subject to. And so if 2260, if there's a contract claim maybe, or they could go to the legislature and seek consent to sue.
Let me ask a similar question in maybe a more helpful way than how I previously asked it. Is if the PUC has exclusive jurisdiction, does the answer to the immunity question make any difference in the future life of this dispute?
I think so, yes, because I think, the way that the Court of Appeals wrote it was, okay, go to the PUC, but then come back to Bexar County. Well, after they go to the PUC and follow the administrative process, I don't think in this instance they come back to Bexar County to sue ERCOT for breach of contract, right? They are going to the PUC saying, ERCOT violated the protocols. Well, the PUC will decide that, and then the PUC's decision will be subject to the judicial review process. And so at the end of that, win or lose, there's nothing left for them, in this case, to go back to Bexar County for. And so to the extent that they attempt to do that, I think the immunity holding is
Because the
important.
PUC can provide complete relief, all the types of relief that they requested are available in the PUC?
The PUC can take any appropriate action against ERCOT, and under 22-251, which is at the last page of our bench book, Exhibit B, it can give any relief it deems appropriate, including injunctive relief. So if the PUC were to believe that whatever conduct they complain about at the PUC needs to stop, the PUC can order us to stop. Which, to answer Justice Blacklock, your question, there is nothing that ERCOT does that the PUC cannot control. It is subject to the PUC's complete authority over its operations.
Ms. O'Neill says that we cannot rule for you if we follow Rosenberg. Do you want to respond more than what's in the briefs to that?
So at the very beginning of Rosenberg, the court very clearly laid out, here's two very important indicia that they're not immune. One, the local government code says that they are not to be given any sovereign or any attributes of the sovereign, including police power. The legislature expressly withheld that power from them. Here, the opposite is true. The legislature said in 39-151D, PUC, you shall adopt and enforce rules, and you may delegate that authority to ERCOT. So the legislature, has sanctioned the delegation of rulemaking power to ERCOT, whereas in Rosenberg, it said that those development corporations can have no attributes of sovereignty, and they're not part of the government.
Is there any rulemaking at issue here, or is the only question whether the rules were followed?
Well, is there rulemaking at issue here?
Are they challenging rules that were made by ERCOT, or are they just challenging the way that ERCOT complied with rules that had previously been made, either by it or by the PUC?
Well, I think that if you get to the heart of their constitutional claim, it's an as-applied challenge to the default uplift invoice rule itself.
Okay, but what about the non-constitutional claims? Is there any challenge to a rule, or is it just what people did that either was or wasn't in compliance with the rule?
So I would say it may not be the rules, but if you look at what they actually pled in their petition, as we point out in our Exhibit C, they do complain about the PUC's emergency orders. They say that those emergency orders led to these excessive prices. So there is inherent in that a complaint about the PUC entering those orders to begin with.
So if that's the case, then why wouldn't the immunity analysis differ depending on whether what we're looking at is a challenge to a rule versus a challenge to compliance with a rule that had previously been set? Don't we look at what function whatever the entity is performing in order to say whether immunity applies? It may be immune for some functions and not others, right?
Well,
It's not all or nothing.
Well, in the sense that ERCOT performs only governmental functions, it's not subject to that governmental proprietary distinction, like this court said in Wasson interest in the 2016 case. That really only applies to municipalities. It doesn't apply to counties, doesn't apply to other state governments that only perform governmental functions, and that's all that ERCOT performs. So I don't think, and immunity being entity-based, I don't know that we would, I wouldn't think it would be looked at that way.
Any other questions? Thank you, Mr. Clark. You have 5 minutes, Ms. O'Neill.
There are several points I'd like to hit. I'd like to start out with ERCOT's statement in Highway 3, where it represented that it is not a part of government under any conventional understanding of that term, and PURA evinces no legislative intent to treat ERCOT as a part of government. Now, that statement, it's not that they made it so much that was important. The court agreed with it, and that's what the court held. Now, that was in answering the question of governmental unit. To be a governmental unit, you need to be an organ of government. To be a state entity, you need to be an arm of government. We can argue the niceties of the difference between an organ and an arm, but that really sort of buries the lead. And the lead is that the legislature never saw fit to come in and even take the more incremental measure of designating ERCOT as a governmental unit for
have
appeal
courts around
purposes.
the state entering damages awards, entering injunctions. How can you reconcile with that with the statutory command that says ERCOT will have complete authority over budget operations? How can you reconcile those two ideas?
Well, you have to focus again on the nature of the entity. That's what this court has always said. And those raise public fisc concerns, but the public fisc is not involved here because these are not taxpayer dollars. It's not subject to state appropriation. Again, the same indicators that were present in Rosenberg.
But
I
immunity is
meant
about
to
more
say
than.
the PUC. So wouldn't the PUC have something less than complete authority over ERCOT's budget and operations if we begin to allow courts around the state to enter judgments for damages or injunctions?
The PUC is in the same position that the municipality was under the Texas Corporation Development Act. And again, I would turn you to the tab that lays out every one of those complete authority indicators, and yet the court determined that it was not a part of the government. It's a very high test, and it's very hard to meet. Let me turn very quickly to the concurrent jurisdiction question.
If ERCOT was decertified, if the PUC decided to decertify ERCOT, what happens to the assets?
The assets would go to a new entity that would operate the grid. They are not the state's assets that has been represented. They are ERCOT's assets, and it would be a winding up just like any other nonprofit corporation where in the winding up, the assets are transferred to a new entity.
Liabilities too?
Liabilities as well, that's right. Let me get to the concurrent jurisdiction question. You'll find that in tab 7. One of the things I want to clear up is D46 in the statute contemplates concurrent jurisdiction. And I'd like to point, Justice Busby, to your question in Panda Power 2. And if you'll focus on that language where the regulation says that nothing in this section, I'm sorry, D46, the regulation says, nothing in this section shall preclude any form of civil relief that may be available under federal or state law. And your question, Justice Busby, was the commission may resolve disputes. Doesn't may suggest the PUC's role is discretionary rather than mandatory? And don't the regs also say that any action the PUC might take against ERCOT should not be read to preclude any form of civil relief that might be available under federal or state law? And here is the gravamen of the question. If the PUC doesn't think that anything they may do precludes any other form of relief, why should we interpret the silent statute to do that? I would suggest the statute's not silent. It does say that you may pursue relief at the PUC, but it doesn't say that you must. This is concurrent jurisdiction. And if the court decides to send something that is within the PUC's particular expertise, as a matter of primary jurisdiction, it can do that. But if you'll turn to tab 4.
Well, the response, when I asked that question today, was that the regulation only applies as between ERCOT and the PUC. It doesn't apply as between ERCOT and a private party.
That's simply not true by the words of the statute. It says any affected person, and notwithstanding anything.
Well,
to the
ERCOT's not
foreground.
an affected person, right? I'm sorry, CPS is not an affected person.
Well, I don't think it technically fits the definition, but the PUC could certainly decide to exercise jurisdiction of it. And another thing, this is not a rate case, and I think that's why it's important to keep that tab 8 front and center. It's not a rate case that would invoke the court's, invoke the PUC's exclusive jurisdiction.
Let's say that ERCOT has a contract with a private party that says, here, we're going to do X, Y, and Z, and it becomes evident during an emergency like what we had here that it's in the best interest of the people of the state of Texas to breach this contract, to keep things running or whatever's going on. Do we want ERCOT to be worried about that lawsuit, or do we want them to do whatever they can figure out is in the best interest of the whole state in an emergency?
They do not have that authority to do that. They can go back to the PUC and request permission, as they requested the PUC's permission to set the price at the market cap. But if you'll turn to tab 4, the order, it says that the authority that the PUC gave it was, it directed ERCOT to ensure that firm load that is being shed is accounted for in the scarcity pricing signals, only while firm load is being shed. It had no authority, no discretion to go beyond that. I see my time is up.
Any other questions? Thank you,
Thank
Ms. O'Neill. Case is submitted, and the court will take a brief recess.
All rise.